Good morning, afternoon, or evening. Just a quick share on something that actually happened yesterday, but I didn't have time to get in here and do it. Yesterday was Wednesday, and we had a pretty lengthy live Q&A. It went a little past the 3 o'clock. I usually aim to have it end by. Anyway, so it was a late night last night, but here's what happened. I have a new client, and he previously was denied at ALJ, not with me, and decided that he wasn't he didn't think it was going to be a likelihood of getting it remanded for a new hearing with the ALJ's decision being a denial. He didn't think the goods were there for a lot of reasons he wasn't happy with prior counsel in terms of not submitting all the evidence, even evidence he may have submitted to them. Then they never submitted it to the judge. Then the judge gave extra time after hearing and they still didn't submit it. Suffice it to say, very frustrated. So anyway, decides he's not going to appeal that. He's going to file anew with new representation. There's actually two travesties here, but we're just going to go over this one. So he went to, I guess a few months ago, went to his field office and had asked about the form for terminating attorney representation. Now, just to be clear, attorney representation will die on that case and terminate naturally if it's not appealed. Because once it's 60 days and the time for appeal is over, that ALJ decision becomes extremely final. However, he wanted to move along and be sure. He went there to get the form, or he brought his own form. I'm not sure which, but anyway, the kind person behind the counter said, oh, this is the wrong form. You need the one where the claimant is terminating the representation, not the attorney, because it's you. So he gives them the correct form. And I will say to you that the correct form for a claimant terminating representation, which they can do, they don't need to get permission from Big Daddy attorney or anybody else. They can terminate via the SSA 1696-SUP1, SUP1. If the 1696 sounds familiar, because the basic SSA 1696 without the SUP attached to it is the way you appointed your representative, attorney or non-attorney rep. So the kind and smart fellow behind the desk gave him the right form. He goes home with the right form, he fills it out, he brings it back. Unfortunately, he gets a different person behind the desk handling him, different customer service, public-facing, mission-critical person behind the counter, and she tells him, you can't terminate. The attorney has to do it. Clearly, that's BS. And he says, this form is yours. It's called claimant's termination of rep. And even in the first line, it says, you, the claimant, have the right to use this form and terminate your representation. There's no spot for a representative. So she just disregarded and sent him away and wouldn't process his SSA 1696-SUP1. Incidentally, if the attorney or the non-attorney rep was going to do it, I believe it would be a SUP2. I don't tend to do it. It's very rare, so I think it's a SUP2. Anyway, so I have last night, after that long day, I couldn't sit on it. He sent me a copy of what he had brought in and how, the one that was rejected. So we haven't filed yet, right? So his claim is dead now as of recently, the old one, and we are going to file a new very shortly. So as I get in some of those last data packets that I'm so obsessed with. But I just wanted to bring up as a complaint of sorts. So I sent it to the manager. Don't know if it actually gets in the manager's hands. I hope so, particularly if it's from an attorney or a representative. No offense to my non-attorney colleagues who are awesome. So my letter was, it was two prongs, but I'm only going to go over the one violation here in this short video, explaining, hey, he got denied. He is going to be filing anew. However, he sought to discontinue his attorney representation a few months ago, and I told him the scoop. I attached his copy that has a date from a few months ago that he had just uploaded for me yesterday. And I said, I just want you to know this. I mean, we're moving on, but this is a violation. It damaged his due process rights. For other reasons, and just to say it briefly, that firm, without his consent, filed an appeal to the appeals council. And he quickly found out about it, probably through his online access that maybe said the status had changed. And they did it right before the deadline for being able to appeal to the appeals council. And he called him up and he said, in no uncertain terms, no, 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 you better cancel that. I did not want that. We didn't, I didn't agree to that. And I believe they had communications, or he had communicated to them previously in email that he did not want to appeal to the appeals council. And they went ahead and did it anyway. Now, why they did that, I don't know. Maybe they're, whatever they're doing, their process was kind of dropping the ball. I can't say it's intentional or anything, but accidents happen. But for that reason, the problem is when you appeal to the appeals council, you cannot file anew. So that other gets canceled and withdrawn as a request for review, which should be entirely possible. And I think I'll probably get him a form for that because the firm did hop to it on that note. I think they got a little concerned that, and sent a fax to the field office same day. I think it was the same day that they filed the appeals council thing. So it's probably all this week. And they sent a, please withdraw that. Basically erroneously filed appeals council review request. I don't have a lot of faith in the field office processing that second one timely, which means we're going to have to wait because they will not accept his claim, or it seems like it's accepted. You're doing all the work on it, and 6 months later, they close and say, oops, just realized you have an appeals council review pending. So it gets really sticky, and it's because things don't work smoothly, at least historically. So that's why I'm a little concerned. So I'm thinking we're going to do, in addition to the letter I sent to the manager, I might have him do the form. There is a form for withdrawing your appeal. We do them sometimes when someone has filed an ALJ appeal and they realize this is a waste of time. I don't even have any goods, which is why I was denied on initial and recon. And I need to start doing my proactive work to make that evidence, and we will refile. So that does happen. It's not common, but it does happen. And it's happened with me. Sometimes I've advised it, and then we put forth a proper case and then they win, as opposed to going to the ALJ with that zero evidence case, or very piddly when you're never going to prevail, and getting a denial that is now ironclad on the books. You don't even have a chance to go backwards, at least with the way of withdrawing the request for hearing and keeping the recon denial. You have a potential opportunity to reopen that whole old application and get all those back benefits. Doesn't always happen, but at least the opportunity is there, which it wouldn't be otherwise. And of course, you always have now the new opportunity to win anew. And we wouldn't, well, it would depend on if you have a date last insured problem. That's all the kind of things we have to look at before we make such decisions. But in any event, wish us luck. I think the form requesting to withdraw the appeal, as opposed to just relying on his attorney's letter, we'll get one out for him too. So they're kind of triple banged on it between me, his old attorney, and himself with this form. And maybe I'll do a video on that form. I don't even remember the number off the top of the head. I always have to drag it out of my files. This is the weird stuff that can happen. And it's like all like administrative technicalities, but it can hold up him filing anew and getting this really going. So I want to make sure that doesn't happen to him. And sometimes it's the squeaky wheel. You have to be the squeaky wheel. Politely, firmly when need be, politely, and you get more piece of honey. But you don't not do it. You don't sit back and just let them trample you with inefficiencies and incompetencies that they just did. So we'll talk to you later, guys. Have a good one. Good morning, afternoon, or evening. Your video is about to start on all things Social Security. Just a quick reminder, we are here every day, 9 a.m. with some sort of tip or tidbit for you. And we are here generally on Wednesdays at 1 p.m. Eastern Standard Time for live stream, live Q&As on everything Social Security. So feel free to pop in a timely fashion, and I will answer your questions there too. Have a great one. Bye-bye. Thank you for joining and taking a listen to this video. If you have any questions that relate to this or anything else with regard to Social Security, disability, retirement, SSI, etc., please do feel free to post it in the comments below, even if it's not necessarily related to this video. And I will see them. And if it's something I can do a video on, I will be happy to do that. If you are looking for representation in a current battle to prove that you are disabled, whether you have applied yet or not, and ideally, if you have not applied yet, that's when we like to come in and start from the beginning. and do our wonders. You can go to joydisability.com, look up to your left, and there's a little link for a free SSD evaluation, and we will take a look at it and let you know one way or the other. If you are looking for a consultation, not representation, or you can't get representation for whatever reason, or it's a non-representational type of issue you need to review, you are more than welcome to order a prepaid consultation. It will be with me personally, and that link is on that same page, joydisability.com, but over on the upper right. Anyway, thanks for staying tuned, and I hope to see you every day, 9 a.m. with our little video shares or live Q&A if you want to join me live on Wednesdays at 1 p.m. Eastern Standard. Thank you so much. Have a great day. Bye-bye.